Welcome to another episode of Conduct Detrimental. Dan Lust and Tarun Sharma. What's up, buddy?
Not much, Dan. Good to be with you. Always good to be on the show.
So this episode, I believe is going to come out right around Thanksgiving. So if you're listening to this after Thanksgiving, I hope you had a very happy Thanksgiving. Tarun, we are going to spend this episode talking a little bit about college sports. We're going to talk about the Matthew Gee versus NCAA case. We certainly just had a jury come in there. We're going to bring on Amanda Christovich of Front Office Sports. Then we're going to talk New York passing time. We have not really talked about state-by-state legislation. That is where I am based. So figured we would use it as an update as to why some states are continuing to pass NIL laws and how that factors in. Tarun, before we get into the fun stuff, we might have some more topics. Maybe, Tarun, you following the Lane Kiffin stuff?
Oh, yeah. That's a lot of fun.
Okay, well, we'll add Lane Kiffin. So, Tarun, before we talk about some real stuff, aren't you going to ask me about my trip to Nebraska?
I was hoping that we would be able to share some Nebraska stories because I just went a couple weeks ago to watch the Gophers win.
Whoa. There's like humble brag that the Gophers beat Nebraska. Like, Nebraska sucks, dude.
We have very little to be happy about because we just lost to Iowa again. So I need this, Dan.
Okay, as much as we are a law podcast, we do talk a lot of sports. Tarun, we were very close to syncing up our trips, which would have been a lot of fun. I flew into Omaha. I will say, how we joke sometimes, like Kyrie Irving, I think, has acknowledged that he went down like a YouTube rabbit hole, and that's how he thought the world was flat. Do you remember that?
Yeah.
So that's something he admitted. So my only real understanding of Nebraska culture is from what I learned on Twitter. Like, that's all I know. So if these people are feeding me misinformation, like, I'm in the rabbit hole. I have no idea. So I was very convinced that Nebraska Cornhuskers fans hated Creighton Blue Jays fans, like hated them, like not like Yankees Red Sox level, but like whatever this level of rivalry would be. And then I flew into Omaha, and I go to my sponsors of our show to give them a shout out, Orr, Horgan, and Flengy. I was with Tom Horgan and Connor Orr the whole weekend. We went out to the bars, with the whole scene, and I'm like, can I tell people I'm flying into Omaha? And he's like, why? And I'm like, because I'm seeing Nebraska. Is it like, can I not be seen in Omaha? And he's like, who told you that? And I'm like, Twitter rabbit hole. Damn it.
I thought the entire Kyrie buildup was because you were going to talk about how flat Nebraska is.
No, and do not disparage my friends over in Nebraska. No, Nebraska is actually kind of pretty. They have cornfields. It's beautiful. It's a different kind of beautiful. Iowa. Oh, well, listen, no. There's no comparison. Nebraska is much better than Iowa. Let's
much better. It is funny. So, like, I drove from Minneapolis. It's about 6 hours to Lincoln, but you drive from Minneapolis and you just, there's nothing between Minneapolis and Omaha. Nothing in the entire state of Iowa, except for as you're passing through Ames, about a couple hours into the drive, they have one of the two Barilla pasta factories in the entire country. It's like there and New York.
Honestly, like, I flew over and there were legitimate cornfields, and I texted my friend Tom. I'm like, are these corn circles? He's like, we don't have aliens in Nebraska. Like, this is not Oswald, New Mexico. But anyway, it was fun. People thought I was insane for calling it a kid in a candy store, but I've been like immersed to some 90% stuff true about Nebraska, and then 10% me getting tricked by some people. But listen, it was a great time. I went to law school. We did an NIL event. I got a crazy invite, Tarun. Justin Swanson, one of our listeners, is a school, works within the University of Nebraska, said, hey, I got you an invite to the Chancellor's tailgate. Do you want to come? And I'm like, that sounds really fancy. And he's like, it is really fancy. And I'm like, okay, let's do it. So it was not the type of tailgate where we were doing like, some nefarious type activities, but it was very prim and proper. This is my favorite part. Ready, Tarun? Over under 3 layers of clothes that I wore for Nebraska.
I hope over. It was freezing.
Six,
yeah.
Actually, six on the bottom, 8 on the top. I was told that this would be really, really cold. Again, I was like, they go, you might freeze. You have to do this. And then anyway, I've been to Buffalo football games. It's not that much worse than that. It was all good. And I got the heartbreaking, crippling loss, Wisconsin winning in the last 30 seconds. So I got the full Nebraska feel. So it is a cool stadium. It's very old school. It's a small stadium. There's not that much room on the sidelines. It's interesting. So we'll give a shout out again to our sponsors, Orr, Horgan, and Flengy. Tom Horgan and Connor were really hooked it up. But we have a loaded episode planned for today. And I guess while we're here, let us do some business. Our podcast is sponsored by Themis Bar Review. Head over to themisbar.com. Use our promo code Conduct. Tarun, how'd you like Themis?
The best. I love Themis. It helped me pass with flying colors. So I support Themis, and I tell everyone who's thinking about where they should sign up, I tell them Themis is the best.
Tarun, that is a very ringing endorsement. So again, here's what we're going to do today. We are going to cover the Matthew Gee versus NCAA case. We are going to talk about New York NIL law. And last but not least, Taryn, assuming you're good for it, we'll do a what to watch for. Cover some Lane Kiffin, who I think is, we'll see. There's a little bit of shades of defamation here. We'll see exactly what comes out. Certain reporter, Taryn, what's the gif? It's we won't curse here, but it's like mess around and find out, right?
Yeah. Well, it's a GIF, but yeah.
What did I say?
A GIF.
I said GIF because GIF is the correct way to pronounce it.
That's not it.
Okay, let's do this. Let us get right into the topic. So first and foremost, Taryn, I think a case that maybe was not on everyone's radars. Again, we'll give our credit to Amanda Christovich over at Front Office Sports. But yeah, the lawsuit involving Matthew Gee, former USC linebacker, played from 1987 to 1991, did not play in the pros, very tragically passed away at the age of 49. And right after his passing, within the statute of limitations, his wife filed a lawsuit for wrongful death. So listen, is it a topic that we love talking about on the show when someone passes away? No. But lawyers are involved. It's a lawsuit against the NCAA, and it's one that has some, important, I don't say precedent, but important impact on cases moving forward from a settlement negotiation standpoint, also from a risk management standpoint, a general business structure standpoint. So we'll get into that with Amanda Christovich. Taryn, any comments on the Gee lawsuit before we move it over to our interview with Amanda?
No, I thought it was a really interesting first opening salvo from people looking to hold the NCAA accountable, and we'll discuss more about how and why it didn't work out.
Without further ado, let's kick it over to our conversation with Amanda Christovich. So we want to welcome to the show Amanda Christovich, and obviously we have one of our contributors, Tarun Sharma, on as well. Last time we had you guys on together, we talked a little bit about the NCAA guidance, I believe in some way, shape, or form. But the main thing that we talked about that seemed to pick up some traction in our circles was our conversation about the Matthew Gee lawsuit over in Los Angeles. That's the former USC linebacker. Amanda, I'm not going to take your thunder here. The jury has come back. Amanda, what do we have?
Yeah, so the verdict ruled completely in the NCAA's favor. They were essentially found to be, it sounded like not even negligent in the death of Matthew Gee, who played college football for USC in the late 80s, early 90s, and then did not play in the NFL. So college was like the highest level that he played. And then he, about 10 years before he died at age 49, the sort of quintessential symptoms of CTE that we all kind of know and understand at this point, he started to experience them. And then after he died, they sent his brain to the CTE center in Boston, and they found that he had it. His wife sued the NCAA for wrongful death. Apparently, the NCAA has no culpability whatsoever. So that's where we're at now. I have many thoughts, but I will let you, direct the conversation where you would like it to go.
Yeah, Amanda, that's pretty stunning, right? Like last time when we had you on and we were discussing this, I thought we were all kind of the thinking that there might be some consequence for the NCAA. What do you think happened here?
Well, I will say that, again, I'm not the lawyer here, but like to the NCAA's credit, I thought that they made a pretty good case for a lot of the sort of outside factors that contributed to his death. There was 4 big boxes of medical records that they brought in a liver doctor, a heart doctor, and they basically said he didn't die, from CTE or complications related to CTE. He died because he was unhealthy. He died because he had substance use disorder. The plaintiffs tried to argue that the reason he had those issues was because of CTE. Like he was overweight because he had no frontal lobe functioning. So he had no impulse control, which also contributed to his substance use disorder. And frankly, I don't know why they didn't hammer home that point more, because it made perfect sense to me, but I don't think that they sort of made that connection. And then the other thing that I would also love to get your thoughts on, frankly, is that the NCAA tried to say, well, even though, it's intuitive that hitting your head a bunch of times is probably not good for you, no one knew how big of a deal this was. No one knew how deadly it could be. No one knew, what the CTE itself hadn't been named yet in the era that he played. And I thought actually the plaintiffs made a better case for that. They showed pretty systemically that the NCAA was totally aware, just as pretty much all sports leagues were, about the dangers of head injuries. They just didn't have the language to describe it. but the jury didn't even seem to think that the NCAA did anything wrong in terms of like the NCAA they didn't even think that the NCAA could have done anything beyond what it was already doing in the 80s and 90s. So my question is, are there players from the current era that develop CTE and die? Will those players have maybe a better chance because we know what CTE is now? I don't know.
Yeah, I mean, so like maybe a little bit of a background. We talked about a lot, but I'm sure if some of the listeners didn't listen to our old segment, which you didn't. Surely it's available in the archives. But yeah, duty, breach, causation, harm. Taryn, you kind of alluded. The conversation that we weren't sure of was like really two elements. Does the NCAA have a duty to not cause unreasonable harm to its players? Yes, I think we could say that. And was there an ultimate harm? Yes, somebody lost their life. So 1 and 4 are pretty much satisfied, but you have to show that the breach of that duty occurred, that the NCAA didn't do enough and they violated the duty. So that's 2. But then you have to show that 2 was the actual cause of the player's death. I guess before I give you my 2 cents, Amanda, do we know, like I heard from one of our friends in the media space that like one juror kind of half spoke to the media, but I understand from like the jury verdict sheet that like we don't really know what they found, if it was that they didn't find that there was negligence, they find causation. Do we have any update on that?
So, I mean, essentially what I heard when they read the verdict was question 1 that they considered was, did the NCAA unreasonably make football more dangerous? The answer was no. To harm Mackey, the answer was no. The second question was, did they not do something that they should have done to make it safer, essentially? And the answer to that was no. And then they said, which I thought was interesting, if either of the answers to these questions is no, stop here.
Okay.
So I'm assuming question 3 may have been causation.
It should have
been,
right? So it looks like,
but they didn't even get to that.
Yeah. So it looks like, right. And that's to Taryn's point earlier. We were sitting here, right? I certainly could see a version where the NCAA is held responsible on a negligence level. And then the 3 of us had a fun conversation about causation. I spoke to ESPN, but yeah, causation is an interesting element. But here for negligence, like there's a lot of questions about whether this will be the like make or break moment with respect to this litigation. There's been hundreds of personal injury and wrongful death lawsuits filed against the NCAA. Hopefully no one gets mad at me, but like this is a $55 million lawsuit. Someone lost their life. Yes, it's a lot of money. I'm not quite sure how to quantify someone's life, and we haven't seen all of his potential, the Economist report about how much he was making, but this is still someone that died close to 30 years after they finished playing. So causation is really always going to be tough. With respect to negligence, Amanda, you and I had conversations while the case was working up. It's like, well, how do we get ourselves into the mindset of what the NCAA knew at that particular time? Like, it's so long ago. So yes, causation is tough because the case is older, but also like from a knowledge level, what the NCAA knew. And I remember, Amanda, we were talking about certain books and records that were lost by the NCAA's like, studies at that particular time. Like, maybe not everybody's alive that was at the NCAA at that particular time that was studying the field. So it's a very hard case to prove. People are going to ask like, hey, how are we bringing this case so late? Isn't that what the statute of limitations is for? Well, Matthew Key passed away, Amanda, 2018 or 2019? It was
2018. And they
right.
filed, the complaint was filed 2 years later. So
right. So like, it's just an oddity that the actual, like in life, like how many times does someone pass away from something that's legitimately caused by something that occurred like 30 years prior? Right.
Right.
Or, it's the problems of CTE. It's not like, you have a car crash, right? And let's say you end up in a hospital bed. You never leave that hospital bed. Well, we can say maybe the car crash happened 2 years ago, God forbid, but like, that's how we know you ended up in the hospital bed. But with CTE, as it was alleged here, it's like a degenerative condition that slowly impacts your brain. So it's a really tough case. It might not really say anything about whether plaintiffs were right or wrong. It just speaks to the difficulty of proving a case from something that occurred in like 1991 in a 2022 courtroom. So it's very difficult. So my soapbox is basically over, but I don't want people to say like, I guess the NCAA was right. Like, no, that's not really what you take away from here.
Right. Absolutely.
Amanda, we also talked when you were here last about the findings from the 1930s that had showed that the NCAA had some knowledge of head injuries caused in playing football. Why do you think that didn't show that in 1989 that USC, that the NCAA would have known about the dangers of brain injuries?
I cannot answer that question. I would have loved to know like how they went through jury selection. I wasn't obviously able to watch that, but it's like, clearly the jury had no prior knowledge of CTE or of head, right? So it's like, I think the NCAA was able to say, well, like based on what we knew, we like outlawed spearing and like got better helmets that like, you know what I mean? They were like, we did some things. To me, the example that actually gave me the most pause was that they had, there was a player who died on the field from getting 2 consecutive minor concussions in 1985. And the NCAA wrote in their like newsletter, hey, this happened, so we're going to create like return to play guidelines. And they didn't implement any return to play guidelines until 1994. And then, of course, they weren't even mandatory. They were just a recommendation. There were no concussion, treatment requirements until 2010. Okay. And even then, the requirement is just that you have to have a return to play protocol. It's not what it is. And if it's not enforced, there's no enforcement mechanism for it. So like, to me, like that was pretty important. But again, I guess the jury like didn't see it that way.
I also want to jump back to the question that you asked at the outset. Do you think whether like a current player would be a better plaintiff? I think it's actually the opposite. And Dan, I'd like to hear your talk on this, but I think given that there is greater public knowledge of the dangers of playing football, of the dangers of multiple concussions, of CTE, and of the baseline tests that currently exist and the return to play guidelines that currently exist, I think it would be very difficult to say that there isn't some assumption of the risk when you are playing football nowadays. Dan?
Yeah, I mean, we talked about this last time. I certainly think in one sense, bringing, Amanda, you mentioned this earlier, like we kind of know the knowledge with respect to CTE. We have certain people on the sidelines tracking for concussive symptoms. So we can certainly spot it much easier. But then, Tarun, to your point, it's a double-edged sword. We all know that, right? We know there were people, we just saw what happened with the Tua stuff. And, even I was watching, I'm sure you guys were, the Saudi Arabia, Argentina game. That defender in the time stoppage got kneed in the face by the goalie. Like, I don't know. I'd be surprised if that was not a concussion. And that's from me just watching enough sports. I kind of know a concussion when I see it. Back in the 80s and 90s, you didn't call that. You said like seeing stars. Like it wasn't really a concussion. So yeah, Tarun, I think the pendulum swings the other way, right? That you might know this. And then at the end of the day, which we haven't talked about, when we go into these cases, it's not like, hey, who's more right? The NCAA or the plaintiff? The plaintiff bears the burden of proof, and the plaintiff fails to satisfy that burden of proof, they lose. So it's not like if you have 25% of jurors that agree with plaintiff, 24 agree for the NCAA, and then the other, 51% are kind of unsure. It doesn't go to the plaintiff. That 50% goes to the NCAA side. It's like, hey, most people agree that the burden wasn't met here. So yeah, again, I mean, the headline from this, and I've certainly started to see people already like, hey, this just must mean it's impossible to win one of these cases. It's not necessarily true. You can certainly see like a player getting, God forbid, a player like going across the middle on a hit, and then they get a really bad hit across the middle from like a safety or even like a goalie in hockey or in soccer. But this, again, hopefully people don't get mad at me, but this didn't seem like the perfect case to test that hypothesis. And I understand it's the first case to go to a jury in some time. Maybe, Amanda, is it ever that has been
ever? It's the first ruling on the NCAA's like responsibility over head injuries. And
I mean, it's the people are going to talk about this case for a long time. And then this is the larger point, like what the NCAA does with this. It's a big win for the NCAA. Is it going to have some, like authoritative effect? Like if someone in like my favorite state of Nebraska, like if there's a lawsuit in Nebraska, like this case has no precedential value over a case there. It has no impact. It's all a fact-specific inquiry. And this doesn't really say anything about the NCAA's liability on a per se level. It's case by case. But what this is going to do, actually, I mean, let me ask you this. Do we have any concept of any settlement discussions that occurred before trial? Do we have any reporting on this? I haven't seen it.
I don't. I mean, I'd have to go through the whole docket, but it seemed to me that the quote that I got from the lawyers about how, it was like they cared about something they cared about like the bigger picture. Like they were like, we want to win this trial, and then, all these other players are going to have their day in court, right? Once we win. So That's, but so one thing I did want to draw attention to related to the NCAA was part of the statement that they sent me last night when they won the case. So they said they will, quote, continue to aggressively defend against cases like this that wrongly try to exploit the legal system to unfairly target the NCAA.
You're giving a face like that is not a good statement. I think it actually is a good statement. And I don't like defending the NCAA. Okay. A little bit of a tort lesson. Amanda, are you familiar with the hot coffee case, the McDonald's hot coffee case?
No, I am not.
Side note, are you familiar with the PepsiCo versus Leonard Harrier Jet case? That's now a Netflix documentary. Homework, Taryn is familiar with it. It's a 4-part documentary series. Here's the thing. There is it's not for better or for worse. There are people in the country that sue big pocketed defendants that have a ton of money. Publicly traded companies like, NCAA is not publicly traded, but they're worth hundreds of millions of dollars. They have a lot of exposure, a lot of lines of liability insurance. So there was something in our country called tort reform that people were suing these like big companies with. Some were not legitimate claims. Some were pretty real. The McDonald's hot coffee case, for example, was a very real legitimate burn, but people want to watch that separate documentary. Obviously, I'm a nerd for law documentaries, but it was a real injury that people spun on the back end to say, hey, these people are suing us for our coffee being too hot. That's unfair. But that people will go after big companies like the NCAA, like PepsiCo, you name a big company, Starbucks, and they'll sue them for a lot of money. And then they'll hope that PepsiCo, Starbucks, whoever else, McDonald's will pay them like, some amount of money to go away, what we call nuisance value, or just some small settlement value. So, we talked about this case at length about causation. We talked about all this stuff. The first second I heard about this case, and I heard about it from you, all credit to you, and Amanda, all your reporting over at Front Office Sports, shout out to you. First time I had heard about the case, I'm like, I think the NCAA is probably in the right. I had a good feeling. And, if you have 100 people or 1,000 athletes that sue the NCAA, it's really easy for the NCAA to pay them all some amount of money to make them go away. But now this case, this result, to hold the NCAA in for 3 years, to buy money, to pay for experts, the depositions for years and years and years, dealing with the big law firms on the other side of this, like you're probably going to have law firms like mine or like Taryn's that be like, you know what, we could sue the NCAA, or they're going to make our life miserable. They're going to file motions. They're going to drive us crazy. And then there's no pot of gold at the end of the rainbow, or at least less likely to be one. So I think the NCAA statement was a little aggressive, the one that you read, but I do think it will be a disincentive. I 100% do. Will people still sue the NCAA, maybe pro bono, and hope for a few bucks here and there? Maybe, but it took us about, Amanda, 10 plus years to get to our first jury trial. I'm not sensing another one's going to happen so quickly.
It appears to me that if you want to sue the NCAA and win, antitrust is better than wrongful death. That's my non-lawyer legal advice. But okay, can I just get on my soapbox really quickly, because
I'm off mine, so you can get on yours. You're good.
Okay, the legality of it all aside, what upsets me as a human being, just like as a person, right, is that, and particularly about that statement about that the NCAA released, and just like my reporting on the NCAA in general, it really irritates me that the NCAA has to be forced to take serious action on athlete health and safety, because that is what it was created to do. It went into this lawsuit. Part of its argument was, we are not liable for athletes getting hurt. That's up to the schools. And it's like, I'm sorry, you were created in 1906 by Teddy Roosevelt to make football safer. So if that's not what you want to be, that's fine. But then what is the point? Truly, what is the point?
First Teddy Roosevelt reference ever on this podcast. But, that was impressive, Amanda.
Cheers.
I think it's pretty clear that that's not what the business of the NCAA is these days. But Dan, before we leave this, I wanted to ask you one more question. So we've talked about the complications that were present in this case with Mr. Gee as a plaintiff. Who do you think the ideal plaintiff would be for a case like this? Because if you can't prove that all of these other maladies came from the initial CTE.
I think the ideal plaintiff, I know we were going back and forth about double-edged sword. To Amanda's point, I think a more recent case is going to help, because it's going to be very hard for the NCAA to say that they don't know about certain risks and ramifications. Even now, the NFL is still changing their concussion protocol in 2022. So, obviously, Dr. Benamalo has been around for about a decade. We're still making changes. So I think a more recent case, but to the larger point, A more recent case, I think, will help with negligence. But for causation, like, and I don't wish this upon anyone, we're just talking in a vacuum academically, something closer in temporal proximity. So like, people have, there's been reporting on like Junior Seau or Vincent Jackson, former wide receiver in the NFL, who had their, unfortunate demises occur a little bit closer to their NFL playing career. And there are also guys that have played, like they played high school, they played college, they played NFL. For Guy's point, like he didn't play, he stopped playing at a high level in his early 20s. So I think, someone that is playing in an era where we're monitoring traumatic, we're monitoring head trauma. We have those spotters in the silence. We have, I don't know, this is controversial, but again, like videotape. Right now, if you play in the NFL from this point forward, every game, every single exhibition game you play in, probably all of your practices are going to be recorded. But we didn't have that same technology in the 80s. So maybe we could track like game concussions. We certainly couldn't track practice concussions. There was probably no high school tape. But with like Rivals and all these crazy tracking sites, like we could probably get a good indication of someone's complete track record to rule out other, causation. And then obviously there's a social media era. There's just more ways to keep track of everyone's activities. Fitbits, different type of trackers. So yeah, I think there will be a case later on that is probably closer to it, but we'll see. I can tell you, like I had a conversation internally at my firm. I think that result that has just occurred, and this is the conversation I had with one of the reporters, like going to trial is this big, like it's like you're playing poker. Like when you go all in, you push all your chips in the middle of the table, you're either going to double up or you're going to go home broke and you're going to have to like rebuy or you're eliminated from the tournament. That's like going to trial, like to kind of cash in. So the only case that has ever gone to a jury verdict, and like Amanda, we were talking about this like last time, it's like everybody hates the NCAA. So like, yes, I think it's a bad case, but could someone want to tag the NCAA? Like, just like, for whatever reason, sure. That's not what happened here. And like, we're at the height of hating the NCAA. Like the NCAA's Q rating is like the lowest it's ever been. And like, that's still low. So, and the NCAA lawyers are not going to be scared of like, oh, hey, juries are unpredictable. NCAA, we might beat you. They're like, okay, well, we're 1 for 1. We'll take our chances. So yeah, I do think it's going to be very beneficial to the NCAA's early resolution efforts. We'll call it that.
Absolutely.
Amanda, anything else to add before we close our chapter 3? You did a tremendous job in this case. You were the first one on the scene to this case. I'll say it once, I'll say it again. And great article yesterday.
Yeah, no, thank you. And thank you for all your insight. I think that my big point was that, the NCAA is not going to take responsibility for athlete health and safety unless it is forced to. So I think that the only way that's going to happen is federal intervention, which we all know is the chances of that happening are, Congress is pretty busy doing other things. So, by the way, it's the same issue with sexual assault, for example. There are no rules in the NCAA's long rule book. There are no rules against mishandling of sexual misconduct. There are no rules against, mishandling of concussions. It does not appear that the NCAA has ever punished a school for not having a concussion protocol. It doesn't appear that they actually, they apparently make the schools send them the protocol, but they don't actually monitor it. So they're not going to do it until they're forced.
We'll end our conversation here. Amanda, thank you very much for all of your time and all of your reporting on a very important piece of sports law history. So that was Amanda Christovich of Front Office Sports. I call her the college sports business reporter, but I know she's just Karen, what did you say? She's just a business reporter, just a sports business reporter.
She's a sports business reporter. She's everything, all sports.
But she's so good at the college sports stuff. We can't put her in that. Like, she's so good at it.
No, she's an everything sports business reporter.
All right, Front Office Sports, our friends over there, they are really at the intersection of sports business. We are sports law, so certainly we love Amanda, we love AJ Perez, we love the whole gang over at Front Office Sports. So we love to give quotes for them, and we love to have them on our show. So yeah, Amanda is great. You can find her handle in the show notes. Okay, Tara, number 2 on the docket. New York comes, I believe the 32nd state to pass an NIL law. So Taryn, we're going to bring on one of my law students from my class, Holly Summers, recent new team member over at Conduct Detrimental.
Helps me with the newsletter.
Helps you with the newsletter. And she just put out an article on Conduct Detrimental. Listen, kids, it pays to write for Conduct Detrimental. You get to come on the podcast. New York governor signs NIL legislation into immediate effect. So Holly, in her spare time, decided to put together an Excel spreadsheet to compare and contrast different state NIL laws were. And I had a feeling she did that the way she wrote her article, and I spoke to her, she confirmed. So yeah, I think Holly's going to be a tremendous guest to come in and speak about what New York's NIL law says. And listen, we're not a podcast just in New York. We're actually in like 100 countries, which might surprise some people. But we want to explain, the back and forth as to why some states are continuing to pass NIL laws when we've established on our podcast that maybe some states it's not wise for them to pass NIL laws, but neither here nor there. So yeah, interesting conversation. Tarun, anything to talk about generally on NIL before we kick it over to Holly?
Well, I definitely want to hear more about your new role with Fordham as well, which coincided with the news of this bill being signed into law.
So convenient timing. I've been speaking to Fordham for a while about being their NIL helper. People have asked, am I helping with their athletes? Am I helping with Fordham? The answer is probably going to be on the institutional side. So, I do some work on the player side. Just the first school that has allowed me to say in a very broad way that we were doing NIL work for them. And we intentionally kept it open-ended because, now there's another level of compliance with respect to NIL deals and fun stuff. But, truth is, right, like we are still waiting for the first school to get in trouble with NIL. And I think the schools that are being forward-thinking and hiring attorneys that are aware of what acts will get you in trouble, you're probably less likely to be that school that is the first one to get in trouble. So, yeah, no, it's fantastic. Shout out to Ed Cole, the athletic director over there. We spoke a lot, and the timing just worked out because we had generally worked out the points, and then when New York passed their NIL law, I got a call from Ed, and we were all systems go. So yeah, I don't really have much more on it, but I was given the clearance, which is rare by a client that they wanted to announce this in tandem. So one of the rare times in legal, for all lawyers, like it's very rare that a client will be like, hey, I want you to announce that you are our lawyer, which maybe it's a little humbling. I thought it was kind of cool. I don't know. It's cool. Tarun, we've done the podcast for like 2 years, and now I have my legal alma mater says like, hey, Dan, we want you to announce this. We want to put up a picture with you. And I'm like, sounds good, Fordham. Let's go Rams. Anything else, Tarun, on the NIL bill, or should we bring in Holly?
No, it's awesome. Let's talk to Holly.
Without further ado, here is Holly Summers, 2L at New York Law School. So, Holly, it's nice to see you on the podcast stage. I'm usually used to seeing you on Monday nights at the Tribeca campus of New York Law School. So it's a pleasure to see you here.
Yeah, thanks for having me. Super excited.
So you got the call today, not because, you are my student. You got the call because you wrote a wonderful article for the website on New York NIL. Holly, I'll let you take us away. Give us some of the higher points about this NIL law, and then we can kind of speak about how this law fits into the larger context of the college sports landscape.
Yeah, of course. So like you said, New York is the 32nd state to enact a NIL legislation that basically gives student athletes the rights to profit off of their name, image, and likeness. Looking through the bill, it was super interesting. Just a few points to me. It has all of the normal things that most states do, like students can't enter into contracts with brands that compete with school licensed brands or brands that already are in contract with the school or anything that is similar to the school in any way. They also have to be sure that they disclose any of these brand deals to the school, which is extremely interesting to me because this New York bill says that it must be disclosed prior to executing the contract. And most states right now just say that as long as the student tells any college, basically official, that they're making this deal, they're perfectly fine, even if it's after the execution of the deal. But New York requires that they do it prior to executing, which in my opinion is extremely important because I've talked to a few different NIL coordinators and compliance directors who have said students come in, they don't know how to get out of contracts, they think they've made a bad deal, and it's too late for them because they've already signed into it. But this kind of allows the school to say, let's think about this for a minute. Let's see what it says, make sure it's legit, and then we can proceed with the deal.
Holly, I agree with you that it's a very interesting provision. In the most recent NCAA guidance that was given out, they did say that they wanted schools to be wary of providing legal services to student athletes specifically and not to students generally. How do you think that this law fits with that guidance, or do you think that this could be a space for future conflict between the NCAA and New York?
Yeah, that's a great question. I think that it is important that the compliance directors and the athletic directors don't give legal advice, but I also think that it's okay for them to come as more of a guidance standpoint, maybe, of make sure that you're reading it through, make sure you're understanding it, and then even saying, hey, the New York law says that you have the ability to go out and get an agent or to get an attorney, and that's something you might want to consider doing, just to be sure that you know what you're doing. Another important thing that the New York bill said is the schools need to provide some sort of financial literacy, some sort of support when it comes to mental health, and then like a backup plan for their degree or some sort of financial backup plan in case things do go south. I really appreciate that, but I think the state could have gone even farther and kind of gone in line with some of the other states and said they need to provide some sort of education on NIL and background on NIL, just so students kind of know exactly what they're getting themselves into.
The question, Holly, that, Holly and Taryn, I guess is for both of you, right? We're in a landscape now, about 17 months into the NIL era. What incentive do states have to continue to pass NIL laws, right? We've talked about this kind of a lot on our show, that in a sense, maybe you're better off being a state that doesn't have an NIL law because there's just one less level of things to pay attention to, one less level of compliance. I'll open this up. I don't really know what the right answer is to this one. Holly, Taryn, anyone want to take a stab at it?
That's a great question, because I think that's kind of what Alabama was struggling with a little bit, being one of the first to kind of give out their NIL legislation and then repeal it a couple months later to still not have anything currently enacted. I think that's what they were thinking of, is they were putting too many regulations on their student athletes, and they wanted to be sure that recruiting was fair or whatever they wanted, just to be sure that they were competitive. I think that a big thing for states, in my personal opinion, is making sure that student athletes are taken care of in a sense that they are financially literate, and that they are also offered services like mental health support that New York passed. And then they also are given the ability to be educated and supported by the schools. And maybe that doesn't help the states directly, but by providing students with that, I think that kind of indirectly, it definitely supports both the state schools and students.
I'm interested to see what the reaction is in terms of requiring that professional representatives be certified according to law. Are you aware, Holly, was that a major issue that unregistered professionals were representing students?
I'm not really aware if that was a major issue, but I do know that a lot of states have put that into their bills, saying that agents have to be either registered through the an athlete agent program and registered with the state, or they have to be a licensed attorney also registered with the state. And usually it has to be within the state the school is located in. I know that Texas has something similar, so does Florida. I think Georgia does as well. And then now New York too. I think that that's important because it just gives students the ability to get better advice about more of the legal issues that could arise from any deals that they're making. But I'm not sure if it has been a problem thus far.
The question that I think we need to ask ourselves is I think, Holly, maybe you know this. How long was this New York bill on the books before it was passed? It was kind of dormant for a while, right? It was
yeah, I think that they proposed it as soon as they could. So last June or last July, and it actually wasn't supposed to be enacted until 2025, I believe. So this is definitely coming a lot sooner than they expected, which is good.
Yeah,
but it's definitely been on the books for a while.
Yeah, so I guess that's the question, right? We talk about it a lot on this podcast. A form of political grandstanding, like why certain laws have to be passed, right? I don't know. Did we need a bill in New York? No. Does it help? I think it's good to have some backdrop. I mean, there's something looming topic that hasn't, as far as I know, hasn't happened at any universities yet that has, reached a national fever pitch, but we'll say looming, growing problem that potentially, right, you could have a sponsor that has a conflict with a particular athlete, right? An Adidas Nike conflict or a Gatorade type conflict. I know in friend of the show, Darren Heitner, helped broker a deal between Gatorade and Anthony Richardson, an athlete at Florida University, which, people don't know. Florida University is the home and the creation of Gatorade, obviously Gatorade. I don't know. Raise your hand if you did not know that was the connection. But that seems to be one where, maybe the term is somewhat cannibalistic, right? Like, why is Gatorade going directly to
Anthony Richardson if they're ready sponsoring the school. So, those level of conflicts are spoken to in this New York NIL deal. And, for playing devil's advocate, maybe you want to have a law in place just to protect the schools to some extent. Obviously, everyone's on the honor system in the NCAA context because the NCAA is not enforcing anything. But probably good to have a rule in the books and to have lawyers like me and saying, hey, listen, someone's coming to you with a potential deal that's conflicting. You're not doing anything wrong in your discretion in turning down this deal. You're just abiding by New York state law. Maybe that's a better message to send. Yeah, I mean, guys, again, let's into the NIL era. States are continuing to pass laws. Let's just say the landscape is not getting less complicated. Tarun, Holly, any thoughts of kind of where we stand as of today?
I think there's some good things in here. The financial training, the mental health services, that's solid. I think that one thing that compliance officers are dealing with is getting that disclosure of these deals. And so if a state law now says you have to do that, maybe it makes it more likely. But on the other hand, who is going to punish a student athlete if they sign a deal and then disclose it like a week or two later? Is that something that the state really has an interest in policing in that manner? So I honestly am not entirely sure why they needed this law, but I guess the way that they're framing it is that it's pro student athlete. So I guess we'll see.
Holly, any final thoughts?
Yeah, I just want to say that I completely agree with what Taryn just said. Senator Parker's main thing throughout the introduction of the bill and trying to get it passed was we're providing protections for students and we want to be sure to protect their eligibility. And that was a huge issue for them and one of their main pushing points. So I do agree that maybe it wasn't necessary, but if it's pro-student, then I'm all for it.
Holly, excellent job. And see you in class on Monday.
Thank you. See you later.
So that was Holly Summers. It was fun, Taryn, to bring one of my students on. Love teaching, and then certainly love teaching NIL on the podcast and in real life in front of live human beings.
One last Nebraska thing. Did you notice that right downtown, very close to campus, there's an Open Doors office there?
I did not know that, but I did have Mike Zorb from Open Doors on the panel. He's one of their higher ups, but I did not know that. But Blake Lawrence and Ani both went to Nebraska, so that would make sense.
I just thought it was cool that they had a real storefront.
Yeah, I mean, I'm not sure exactly what they do. It's all existed and existing on the internet, so to speak. But Open Doors is obviously a leader in the space and just happens to be based from Nebraska. Okay, Taryn, let's do this. Let's finish up. We're not going to cover any type of World Cup issues. I know what's going on in Qatar with the alcohol. We're not going to cover that quite yet. I think people were predicting that this would be Fire Festival. Not quite. I think the stadiums are world class. So, listen, we call it like we see it. We're talking on this podcast defending the NCAA. I'm defending, which I did not expect, defending the Qatar setup, which people were very, very critical of. I don't know. To me, I think, again, not going to compliment the country of Qatar, but I think the setup looks pretty nice and people had set the bar pretty low. But, Taryn, what I did want to talk about, a story that has popped up on college sports message boards, and it's kind of a interesting story. So, Taryn, you want to lay us out on the Lane Kiffin stuff?
Yeah, anyone that knows Lane Kiffin knows that he is terminally online. And so
Lane Kiffin, coach at Ole Miss University.
Yeah, at the University of Mississippi. He is a very fun follow on Twitter. Highly recommend it. So on Monday night, the 21st, John Sokoloff, who is a reporter in Columbus, Mississippi, he tweets out that Ole Miss head coach Lane Kiffin plans to step down as the Rebs coach on Friday and head to Auburn to become the Tigers' next head coach. And so he says that Lane to Auburn is happening. Well, Lane Kiffin quote tweets this and says, "That's news to me, John. Nice sources." And then he has a bunch of emojis. But then Lane doesn't let it go. He prints out a piece of paper that says, "This just in, breaking news, John Sokoloff of WCBINEWS in Starkville, Mississippi, plans to step down as lead anchor and head to WLOX to become their new lead anchor."
So then the WLOX guy popped in. He's like, "This is fake news. This is not true."
No, he said, according to Lane Kiffin, I'm being replaced. It's a crazy coaching season. And Lane said fake news. But now he's retweeting all sorts of memes about John Sokoloff, which is just amazing.
Can we talk about the best one? We don't talk about all the best one by far. The meme, Taryn, with what that kind of bro-y guy posing next to the grave, giving like the peace sign.
Yep.
So that guy in the meme is named John Sokoloff, and then next to him there's a grave that was just buried. It says John Sokoloff. So why we bring this all up, right? Why we're not just talking about random Lane Kiffin internet trolling. John Sokoloff is a reporter. He's a blue check mark verified reporter at a station, and I guess it's Mississippi, right? He's Mississippi, John Sokoloff. So he's reporting that Lane Kiffin is going to switch to Auburn University. Now, I'm not sure necessarily what his sources were. He did say, which was bizarre, like in the initial tweet, Tarun, like, Auburn has reported that they have not offered the job to anyone. Therefore, Lane Kiffin to Auburn is happening. So it was a bizarre, it was like the way I read it is correct. That's what it said. He said, Auburn has not offered the job to anyone. Therefore, Lane Kiffin is going there. So, he has not issued a retraction in any way, shape, or form. So you would think in that instance, when you have Lane Kiffin, the coach of a very big Power 5 program in the SEC, dunking on you, you would think that you would issue an apology and a retraction, say that you got it wrong. But he is standing by his reporting. And let's just say there are people in his replies that are not too happy. So obviously in college sports, we've seen this. We've seen coaches say they're not going anywhere. Most famously, Nick Saban said he's not going to go to Alabama. And then, he's like, I'm not going to Alabama. And he's like, just kidding. Like, I'm going to Alabama. And, it's happened a couple of times. So here's my question to you, Tarun. Let's say this was entirely 100% false, that John Sokoloff made this up, complete fabrication. Okay. Could Lane Kiffin sue John Sokoloff for defamation?
No, I don't think there's any actual malice involved in this situation.
No, I'm making up a hypothetical. Let's say we knew that Sokoloff made it up. He entirely made this thing up.
Yeah.
Do you think there could be a lawsuit here?
I mean, maybe, but the standard, I think, is still entirely too high for a public figure like Lane Kiffin to be able to sue for something like this. And it's not just Sokoloff who is, trading in these rumors. I think a lot of people are saying these sorts of things that, the Lane train is going to Auburn and all of that. You even have the Spokane Indians, which is a minor league baseball team, saying that he plans to step down as the Rebs coach and head to Spokane as a ticket services coordinator. And Lane is retweeting stuff like that. So I don't think Lane has any intention to sue about this. I think he's having fun about it. But I think even if he did, I think that might be a difficult case to make as a public figure.
Obviously, people are having fun with it now. People are doing parodies. People are making jokes. They're doing GIFs or GIFs. What do we want to say to them? We want to say it's GIFs?
GIFs. That's just what it is.
No, there's a very lively debate about what the term is. So I'm not going to concede the point. Yeah, if someone had made the thing up, right? Let's go through the elements, right? If you have someone, you make a statement about a public figure that you know it to be false, and you do it in such a way where actual malice can be established, and it harms his reputation in some way, shape, or form, it could be actionable. Again, like total hypothetical. But what is the harm to Lane Kiffin, right? If he ends up staying at Ole Miss, and potentially, right, maybe Lane Kiffin is leaning into this to get some more money from Ole Miss. It's certainly possible. So I'm not really sure. Again, let's assume there was actual malice, which there was, but assuming there was, I'm not sure there's any type of harm. So the only reason I asked this, and I posed it in the podcast, Aaron, a number of people drop in my DMs and ask me that question. I don't think there is any, at least cognizable damages or reputational harm. Would you agree with that point?
I would. And it's, the reason that people are saying these kinds of things about Lane is because he has hopped job to job before. He left Tennessee after 1 year, most notably. And so, I think Lane perfectly accepts what his reputation is and finds it to be funny, and he leans into it, like you said. So the news is today that he's supposedly meeting with the team and might sign an extension. So we will see. I mean, what if after all of this that Sokoloff is correct? Auburn, that's a great job. So he might want to be the Auburn head coach.
Tarun, I don't know if technically where we fall in the spectrum of media. Like we're somewhere between the lawyer media spectrum here, right? Where we are, I guess, a media podcast to some extent. But John Sokoloff is in the business of reporting, right? This is, by all indications, really like a make or break moment for him. He is not backing down by any way, shape, or form. You must believe he has some sourcing here. If Lane Kiffin does go, that is a potential make or break moment. Ask Brian Windhorst. Tarun, fun fact, Brian Windhorst, Nebraska resident,
Got a
No
little bit of
way.
a message from him acknowledging my existence in Nebraska. Did not offer to get a drink with me in any way, shape, or form, but acknowledged.
Come on, Wendy.
Yeah.
Why
Yeah.
would he do that?
No, he's. I got you. Yeah, I mean, at one point, Brian Windhorst made his career on LeBron, where he was going to go, and being a Cleveland Cavs reporter. So this guy is Sokoloff. Let's pay attention to him. If Lane doesn't go, I'm not. I'm following the weeds here. Well, is somebody going to sue him? The only one that has standing to sue him again. Sometimes we answer the obvious questions, but Lane Kiffin's the only one that can sue him. Maybe Ole Miss University to some extent. I could maybe make that argument. But yeah, I do not think there's a case here, but gives us a good excuse to talk about sometimes the lighter side of sports. Speaking of, Taryn, you ready for this?
Yeah.
What to watch for, Taryn? We do it whenever we remember to do it. Give me your what to watch for, and then I will come up with my.
Yeah. So rivalry week for college football. I've had a great season of being able to go to a lot of great college football games. And that is going to continue for me this week. My future in-laws are taking Hadley, my fiance, and I to the Ohio State Michigan game. It's going to be number 2 versus number 3. And I think it's just going to be an incredible matchup, but I'm most savoring it regardless of the outcome because this might be the last of its kind. You consider the fact that we're going to a 12-team playoff in the not too distant future. And with a 12-team playoff, this game would be solely for seeding. Either way, these would be 2 of the top 12 teams in the country. So playing with all the marbles on the line, not just the rivalry, the Big Ten championship, the college football playoff berth, all of that coming down to 60 minutes or maybe more this Saturday is going to be incredible. And I'm very lucky that I'll be able to watch it from a great vantage point.
My what to watch for, I was going to do one about USA soccer, obviously root for USA, yada, yada, yada. Here it is, Taryn. Here's my what to watch for. While I was in Nebraska, shout out to Nebraska. So this podcast is not sponsored by Nebraska, but maybe it should be. So I woke up, Taryn, at 2 a.m. to fly out Friday. So I woke up at 2 a.m. I flew in on a Banshee. I got in at 11, and I drove to law school for the NIL event. Then we, went to do some radio hits, different stations. There's a whole spiel. I have it documented on our social media accounts. But in any event, we go to the bars. Taryn, it's about 7:30, and I just turned to my guy Tom and Connor. We're all together, and I'm like, guys, I'm going to pass out. It's been a long, long day. So I pass out, right? I wake up because my body clock is used to having 3-year-olds and 1-year-olds wake me up. I wake up at 4:30. I have no kids, I have nothing to do. Can't go back to sleep. Ask me what I do, Taryn.
What did you do?
I watched the thing I'm about to recommend to all of you, and I thought it was amazing. Ready for this? Leonard versus PepsiCo.
Oh,
Taryn,
yeah.
your face right now. Okay.
Yeah.
4-part documentary series. It's on Netflix. This is a very famous case in law school. People will know. This is the case in the lawsuit about Leonard wanting his Harrier jet from PepsiCo. He gets the 7 million Pepsi points. Netflix did a wonderful job breaking this down. Now, Taryn, have you seen it before I give you a spoiler?
I've not seen it. I'm excited to see it. I've obviously read the case.
I'm not going to give any spoilers about, what people know what the case happened in the case. There is a very famous person, not famous at the time, but was brought on, retained to help on this case in their 20s. A very famous individual that I have never heard about being associated with this case. This person has since gone on to fame or infamy. We'll put it that way. Your eyes are big. Leonard versus PepsiCo stuff I had never learned about this case. Depositions that should have been taken. This is in the weeds, but it's also just a really fun Netflix documentary. So listen, if they could do the story on Leonard versus PepsiCo, Cleveland Guardian story is not far behind. We're going to make this happen.
I can't wait. It's on my list.
It should be. Listen, whoever has a list, I have a list in my little notes. I always move things up and down. Leonard versus PepsiCo is going to number 1 on all of your lists. That's it. That's our only requirement. Taryn, anything to add?
Yeah, Dan, how about Aaron Judge being spotted in San Francisco? He's from there, but gave a little wink to the camera.
Okay, that was a great reminder. And that's why I always asked if there's anything else, because we have to figure this stuff out. We recorded an episode last week, and I should mention one of our more popular episodes of all time. We talked about sports crypto, we talked about FTX, all this fun stuff. And we had on Ezra Levine of Collectibles, who said, what's the deal with the Aaron Judge home run ball? We had this whole interesting conversation about if Judge signs with a team that's not the Yankees, that might hurt the value of the ball. So Ezra, in his professional capacity, said, I have no idea why this ball was not put up for auction much sooner. We have an update, team. If I had a fancy soundboard, I would hit a button right now, like a siren going off. That is exactly the one I was going to use. Jeff Passan emerges, ESPN reporter, and says that the ball is now being put up for auction. I think Golden Auctions is who's going to be selling it. And here's the big one. He officially, this guy who got the ball, I think is Corey Younger, or something like that is his name, but officially rejected a $3 million offer. So let's just put this in context for a second. Mark McGwire's 70th home run ball, which was the record at the time, was sold for $3 million. Aaron Judge's home run ball, congrats. It's the American League record. Congrats. It's the Yankee record. It's not the record. If Mark McGwire's ball sells for $3 million, like 10 plus years ago, why Aaron Judge's ball is necessarily going to go for more than $3 million. Tarun, we talk about assumption of the risk a lot. Assumption of the risk. How are you turning that offer down?
That's a lot of money to turn down, but maybe he's thinking that the Yankees will re-sign him.
I am not going to listen. I'm happy to be wrong, and I'm always rooting for people to make their money, right? I'm not rooting against people and wishing ill on people, but I would chances of that ball going for over $3 million at 50-50 at best. 50-50 at best. And then you have to ask yourself, like, you caught a ball at a baseball game and you're turning down $3 million. Like, seems like a risky proposition. And then to Ezra's point, former guest of the show, now friend of the show, that ball probably should have been put up long ago. It should have been put up before, in the middle of the playoffs, when the Yankees could have been making a speculative World Series run, and Judge potentially could have been the World Series MVP or the ALCS MVP. But you lose all of that when you let that play out. But there was a real fever pitch to Judge. You could have put that ball up for auction very quickly. And I think we are starting to see movement on the ball because of this fear that he might sign with the Giants or the Dodgers. So let's make that, Tarun, our collective what to watch for. How about that?
That's right.
Collective what to watch for. Tarun, excellent job as always, buddy. And have a very, very lovely holidays if we don't speak again. And hope you had a very happy Thanksgiving.
Great to see you, Dan. Thank you.
We do it each and every week. Conlan. Well, listen, you were 7-1. It wasn't meant to last forever. Conlan, you gave us 2 picks last week. Neither of them hit. So I don't know if our Bettor Edge, our sponsor of this podcast, is going to be too pleased with you, my friend.
Listen. All good things have to come to an end, but not really an end. Just, a brief pause. I mean, maybe I got a little ahead of myself, but who wouldn't at that record 7-1 coming in? Look, the Bills under was kind of a BS call there because the game got moved after we recorded to Detroit. So obviously the over shot way back up and ended at around 51 still. With that said, the total was at 54 at the end of the game. So my under wasn't close to hitting really a full score. And then
Hold on a second. You told everyone, you're like, oh, it's a bonus pick. It's going to be the snow pick. There's going to be 6 feet.
And I didn't see an inch of snow on Ford Field in Detroit. Did you?
Listen,
so it was contingent upon the snow. It was contingent upon the snowstorm, but whatever. Hold
on for a second.
Go ahead.
Shooters have to shoot. You miss 100% of the shots that you don't take, Conlan. If you would have asked me, and you still can, to give you a do-over on that one, I think of the Lust Resorts World and Casino Sportsbook. I think we're going to take that one off the board, Conlan. I think that's only fair. You gave a pick, the venue changed. I'm going to give you that one to if you want to.
All right. Well, it's fair. It's fair, and I appreciate the judgment call there. So, but
okay, yeah. No excuse for your 40-3 blowout for the Vikings, but I was feeling generous.
That was embarrassing.
So how about that?
Yeah, that was embarrassing.
Okay, Colin. So listen, Bettor Edge segment. Bettor Edge is our spot for social betting. People pick the lines. People put them out there. We find them. We identify them, and Conlan picks the winners. So 7-2, Conlan officially as we enter this week. So Conlan, where does the money find us this week? Where do you want to take us?
I want to take us back to my boys, my team, the New York Football Jets. A lot of drama surrounding Robert Saleh's gangrene group this week. And today he announces a quarterback change. Former last year's number 2 overall pick, Zach Wilson, will be inactive this week. Not even just benched, but he won't even dress. He was that dreadful last Sunday against the New England Patriots in that incredible 10-3 loss on the punt return. So this week, let me go right back to him because I'm a Mike effing White believer. I saw what he did against the Super Bowl runner-up, the Cincinnati Bengals last year in dominating fashion, won that game. The Jets right now playing host to a possible Justin Field-less Chicago Bears team. who Justin Fields injured his left shoulder in the loss to the Atlanta Falcons last weekend. So I like to go the Jets at home at MetLife -4.5 with Mike White under center. I think this revitalizes, gives a little energy shot in the arm to this Jets football team, who's still 6-4 and very much in the playoff hunt. So let me go gangrene -4.5 against what will be a team, Chicago, without Justin Fields, and it has a very poor pass defense.
Colin, I like the pick. I'm happy that you're going. You're looking at the Jets here. I'm not really happy the Jets are your team. But how about this, Colin? We talk a lot about what athletes should and shouldn't do, what they're saying, what they're not saying. You didn't mention it, so I'm happy to say it. Zach Wilson, right, had a putrid performance. The defense showed up. They held the Patriots to 3 points the entire game. Zach Wilson was asked point blank, right? Do you feel a little bit of accountability for your performance in offense and really kind of hanging the defense out to dry? And he goes, nope. And then his eye said, next question. So that's why he's not dressed. So, Conlan, at some point, maybe you and I will open up the consulting firm. Athletes can speak to us before they say or do not so smart things. Kyrie Irving can call us up. And, maybe Zach Wilson's our second client. So Zach Wilson is out of a job this week. So, Conlan, we'll trust you on this. You're 7-2 with an asterisk, but 7-2-1. I forgot we had a tie in there.
There was a push in there. It was actually funny. Funny thing is, the Vikings now are the only team in the NFL, I think, that I bet twice. The Jets will be this coming week. They'll be my second time betting them. The Vikings are 0-1-1 with me. So I think it's time to hang up Kirk Cousins' group because they have not brought me a win yet.
All good, Colin. Tremendous job. And just for our podcast, because I think this is important, right? Mike Lawson is a mean 6'5". We figured this out. Colin Farrell, how tall are you? You're pretty. I think you're
I'm a clean 6'1". So 6'1.5", maybe on a good day, but 6'1", I will say. So me and Mike, yes, we are the enforcers of Conduct Detrimental. Okay, you don't want to cross the other two of us.
Now, if we were trying to pick someone to volunteer as tribute to fight to the death for Conduct Detrimental, do you want to be our guy, or are we giving that to Lawson?
No, we'll give it to maybe Lawson. There's a few of our female colleagues that like to think that they are the toughest of the group. So who knows? There might be whoever misconduct is run by. I think there's Stephanie and some other girl. So maybe her. But we'll see. I don't know when that will happen. But no, I'll give it that. Fighting seems more their style. I think I'm a little above that. But
yes, Emily has come up on this podcast. I do think Emily should be my choice for the female side. Speaking of fights, Colin, then we'll close the breaking news as we are recording this. Colin, you and I usually record when we're heading home from our respective employers. But Colin, Michigan State, criminal charges filed against the Michigan State Spartans. How about that?
Yeah, well, I mean, I think that GIF going around on Twitter lately, the F around and find out scale, those guys they F'd around and now they're finding out. So, you know what I mean? It's just stupid and shameful on all accounts. And, you know what I mean? They're going to get what's coming to them. But that's all I can say on that matter.
Yes, I'll handle this part and then we'll call it a day. 7 Michigan State Spartans charged with criminal charges, felonious assault, assault and battery, and then just pure assault. So, yeah, it's we joke on the podcast about what things should and shouldn't be criminal charges, right? Devontae Adams, we talk about Draymond Green, but this was off the field, not even really close to being on the field in the tunnel. So you've now formal criminal charges. I'm sure we will talk about that more in the future. Conlan, excellent job, my friend. Hopefully we take this to the window and another cash. So Conlan, enjoy your weekend and I'll speak to you soon, buddy.
All right. Happy Thanksgiving. Talk to you later on.
That'll do it for another episode of Conduct Detrimental. For myself, Conlan Farrell, Tarun Sharma, Holly Summers, and Amanda Christovich, and all of us here at Conduct Detrimental. We will see you next time on another episode of Conduct Detrimental. Happy Thanksgiving, everyone.